Have you ever bought something that turned out to be faulty or maybe just flat out broken? Yeah, we've all been there. But what you probably don't know is that your power to get that fixed, your actual rights as a consumer, were basically forged in this wild story involving, and I'm not kidding, a snail and a bottle of ginger beer. Okay, let's get into it.
It seems like a pretty random question, right? I mean, how could some court case from almost 100 years ago have anything to do with you when your brand new smartphone starts glitching? Well, it turns out it has everything to do with it. This one single, kind of gross event laid the foundation for all the protections we just take for granted today. And that's where we meet the landmark case, Donoghue versus Stevenson. Now, this isn't just some quirky little story for law students. No, this is the origin story of modern consumer law, and it all comes down to the duty of care that companies owe to you and me. So picture this. It's 1928 in Paisley, Scotland. May Donoghue is at a cafe, and her friend buys her a ginger beer. She's enjoying her drink, but when her friend pours the rest of it out, this decomposed snail plops into her glass. As you can imagine, she gets sick. We're talking shock and gastroenteritis. Just a truly awful experience. Okay, so here's where it gets complicated. Because her friend bought the drink, Mrs. Donoghue didn't technically have a contract with the cafe owner, so she couldn't sue him. If she wanted any kind of justice, she had to go after the guy who made the drink, Mr. Stevenson. The only problem? Back then, the law made that almost impossible. And this really gets to the heart of the old way of doing things. Before we had our modern laws, the entire weight of getting justice, the whole burden of proof, was dropped right onto the shoulders of the person who got hurt. The big legal hurdle she had to jump over was this concept of negligence. It meant her lawyers had to somehow prove that the manufacturer had personally been careless in his bottling process. Now just think about that for a second. How on earth is a regular person supposed to prove what went on inside a factory they've never even seen? So the bottom line is the whole system was just stacked against the consumer. It was this long, incredibly expensive, and usually pointless battle to try and prove what a company did or didn't do behind its closed doors. For most people, justice was just totally out of reach. But thankfully, that's not where the story ends. Here in Australia, things took a massive leap forward with the Australian consumer law, what we call the ACL. You can think of it as a new shield for all of us, a modern safety net written into law. So instead of having to dig through decades of old court decisions, like the snail case, we now have a clear, written rulebook. The ACL basically took the spirit of consumer protection and turned it from a really difficult legal argument into a guaranteed right for everybody. And right at the core of this new shield is a really powerful idea that completely flipped the power dynamic. It's a concept called strict liability. And this, right here, is the game changer. With strict liability, it doesn't matter anymore if you can prove the manufacturer was being careless or just having a bad day. If their product has a safety defect and that defect hurts you, they are responsible. Full stop. The focus isn't on the manufacturer's intentions anymore. It's all about the safety of the product itself. And this comparison just makes it so clear. In the old days, you basically had to be a detective, right? Investigating the manufacturer's every move. It was all about what they did. But now, under the ACL, the focus is squarely on the product. You just have to show that it was unsafe. So the question went from were they careless to was the product effective? And that is a world of difference. So that's enough history for now. Let's bring this into the 21st century and see how this powerful system actually protects you today. A great example is this recent case with Voltaren Osteogel. Now, the problem here wasn't a physical defect like a snail. The issue was that the product was marketed as being way more effective for osteoarthritis than it actually was. And under the ACL, making misleading claims like that is a major breach. So the ACC, our consumer watchdog, stepped in and enforced the law. It just goes to show you, these protections cover not just what a product is, but also what a company claims it can do. So let's just quickly wrap up this whole journey. We've gone from a world where you had to prove a company was negligent to one where you just have to show the product had a safety defect. The focus has completely shifted from the company's actions to the product's actual condition. And this has made the burden on you, the consumer, so much lower, all because our rights are now based on clear, written law, not just old court cases. So, yeah, the next time you have an issue with a product, you can send a little thank you to May Donahue and her very unfortunate snail. But this all leaves us with a pretty big question for the future, right? As our gadgets get smarter, we're talking AI, constant software updates. What's a safety defect even going to look like? And how is the law going to keep up? Well, that's the next chapter that's still being written.